So we need to talk about a new Supreme Court case attempting to build off of a prior unanimous Supreme Court decision, which impacts all of our rights, which would prevent the unlawful search and seizure of firearms without a warrant. So let's break down what is happening in this critical Supreme Court case. Now, before we jump into this video, if you want to support the channel for free, please consider subscribing to the channel. That, of course, helps the channel to grow. And then just drop a positive comment down below because that tells the algorithm that you appreciate this type of 2A content and it should share it to more people. As I mentioned in the intro, in this video, we're going to be talking about a new Supreme Court case involving when police can enter someone's home without a warrant. This case tries to use a prior unanimous decision issued by the Supreme Court, and that involved the warrantless search and seizure of firearms within your home. This new challenge is trying to use and expand on a prior unanimous decision issued by the Supreme Court in a case called Caniglia versus Strom. In Caniglia, the Supreme Court found that the community caretaking exception to the Fourth Amendment's warrant requirement does not extend to the home. Justice Thomas issued that 9-0 opinion in the Caniglia case and found that what the police officers did in that case was unlawful. And now this challenge is trying to expand upon that. This challenge, Case versus Montana, attempts to use and expand on that decision. Now, the facts surrounding this case and this challenge, I'm going to be honest, is they're not really the best. They're not my favorite facts. This is not my favorite plaintiff and petitioner here, but we've seen the Supreme Court grant cases like this in the past in cases like Rahimi and other challenges where the plaintiff was not perfect and the facts also were not perfect. Now, this lawsuit results from the individual Mr. Trevor Case and his ex-girlfriend who called police saying that he had threatened to harm himself and that he might also have a gun. Police officers entered his home without a warrant nearly 40 minutes later, even though they suspected that Mr. Case was not attempting to commit suicide, but maybe he was just trying to get the police there to do it for him. Officers shot Mr. Case during the resulting chaos of them entering the home, and Mr. Case was then later charged and convicted of assaulting an officer. Mr. Case argued that the officer's warrantless entry into his home violated the Fourth Amendment so that the gun and the other evidence that were collected during that whole investigation should also be suppressed. Those arguments were rejected by the lower courts on review, but eventually this case made its way to the Montana Supreme Court. The Montana Supreme Court affirmed the denial of his motion to suppress all the evidence, but it was a mixed opinion. There was a 4-3 split on the Montana Supreme Court, and so there was a lot of back and forth between the judges. 3 of them wanted to rule in favor of Mr. Case, and 4 ultimately ruled against him. Now, in this challenge, Mr. Case argues that the reason belief standard improperly dilutes prior court's decisions where the court held that police may enter a home without a warrant when they have objectively reasonable basis for believing that the occupant is seriously injured or imminently threatened with such injury. And he argues that the holding below by the lower courts in his case conflicts with holdings in other court of appeals like the 2nd Circuit, 11th Circuit, and then also the District of Columbia. And he argues that it goes against prior Supreme Court decisions in a case called Caniglia versus Strom. He argues that the facts objectively reflect that there was no ongoing emergency requiring the immediate action, and he says that the police officers sat outside his home for 40 minutes. They all agreed that there was no emergency, and that if they entered the home, maybe they would give Mr. Case what he actually wanted, but they still decided to enter his home without a warrant, and that resulted in the entire incident. Now, one of the big things in this challenge is Mr. Case and his attorneys are trying to cite to the unanimous decision in Caniglia as support for their position and why the Supreme Court needs to review this case. They state that this case gives the court the opportunity to clarify the contours of the exigent circumstances doctrine as applied to the emergency aid situations, an issue that has consistently confused and divided the lower courts since Caniglia was decided. They go on to state that the court should take this case to resolve the standard for warrantless home entries under the emergency aid exception. In Caniglia, the court made clear that while community caretaking concerns did not alone justify a warrantless home entry, police could take such action to render emergency assistance if exigent circumstances were present. But because that case provided no occasion to examine the contours of the emergency aid exception, courts remain divided and in need of guidance. They argue that it's time for the Supreme Court to clarify the Caniglia decision and grant review in this case. And they argue that the lower court issued an opinion that is contrary to Caniglia and the Supreme Court needs to correct that. Now, if you're not aware of what happened in that prior decision by the Supreme Court, which was the Caniglia case, Essentially, one night during an argument with his wife, Mr. Caniglia got a handgun out, put it on his dining room table, and just told his wife, I guess in an argument, that she should just shoot him and kind of get it all over with. Now, his wife then subsequently left the home, I believe stayed the night at a hotel. Now, the next morning, she tried to call her husband, but she couldn't reach him. And so she decided to call police and requested essentially a welfare check on her husband. Now, after that, both the police and the wife met at the home and they found Mr. Caniglia just sitting on the porch. And they talked to him. They realized nothing was really wrong. But really what ended up happening is, there were some statements made by Mr. Caniglia and the police thought maybe he did still pose a risk to himself. And so they called an ambulance and they eventually took him to the hospital for a psychiatric evaluation. Now, during this whole interaction, the police promised that they would not confiscate any of his firearms. However, once the ambulance left, the police did seize Mr. Caniglia's weapons. And according to his wife, the police officers told her and essentially lied to her that her husband said that yes, he wished to have his firearms taken away. The case eventually made its way to the Supreme Court back in 2021, and on review, the Supreme Court issued a rare 9-0 unanimous decision in favor of Mr. Caniglia. The majority opinion was then authored by Justice Thomas. Now, Thomas stated in the opinion that the Fourth Amendment protects the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. The very core of this guarantee is the right of a man to retreat into his home and there be free from unreasonable governmental intrusions. Justice Thomas therefore found what is reasonable for vehicles is different from what is reasonable for homes. Katie acknowledged as much, and this court has repeatedly declined to expand the scope of exceptions to the warrant requirement to permit the warrantless entry into the home. And based on that, the Supreme Court unanimously found that the warrantless entry and seizure of Mr. Caniglia's firearms was in fact unconstitutional. Now, since then, the Supreme Court has not considered any of these cases. They have not expanded on Caniglia since 2021. Mr. Case argues that the Supreme Court should revisit this issue and potentially expand the decision so that it also applies to his circumstances. Now, this challenge here has been distributed to the Supreme Court a couple times now, most recently for conference on May 22nd. Now, this case is important because they deal with your protection against the search and seizure of firearms within your home and when police officers can come into your home without a warrant. There are plenty of real-world examples of something like this happening, and this is just one of those cases that also demonstrates that. Like I mentioned, this is not the best facts and the best plaintiff that we've ever seen go to the Supreme Court on an issue like this, but we've seen the Supreme Court grant review to cases like this one, for example, in the Rahimi case. The Supreme Court now has an opportunity to clarify or potentially expand upon the unanimous Caniglia decision, which can have direct downstream implications on me and you about the type of protections that we have from police officers or other individuals or other federal agents from entering our homes under warrantless search and seizure situations, and when do exceptions apply. This is one of those cases that we're going to be watching closely to see if the Supreme Court grants review to. The Supreme Court tends to like Fourth Amendment cases, and since this one ties directly into a prior decision issued by the Supreme Court in the Caniglia case, and a lot of the issues that have happened at the lower court levels, this is one of those cases that's maybe a prime candidate for the Supreme Court to actually grant review to. Like I mentioned, it's been sent to conference, and now the Supreme Court is going to decide if they want to grant review to it. So as we get more information, as this develops, I will let you guys know. If you like this video and you like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like, comment, and subscribe. And don't forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.